And joining us now from Washington with a closer look at the ebook price-fixing trial and what it could mean for Apple and the industry is antitrust attorney David Balto. He's also a former trial attorney for the Justice Department's antitrust division. David, thanks for joining us this evening.
Thanks,
Michelle. Thank you, David. Let's get straight into it. So the question before the court is whether Apple's negotiating tactics amounted to a conspiracy that reduced competition in the market for ebooks. Apple contends it did not collude with the publishers or hurt the ebook market, and that it was just good business and good negotiations. What's your take?
I think the government has compelling evidence, Michelle, that Apple acted as the cartel ringmaster. It brought all the publishers in line to enter into these agreements to significantly increase the prices of ebooks for consumers.
So if the government has compelling evidence here, what are some of these things that it's going to use to prove its case?
Well, I think you've got the agreements themselves and the statements by people like Steve Jobs about what their goal was here. And I think there's very straightforward evidence here about the clear anti-competitive impact, that consumers paid more. You know, the moment this case was brought, or soon thereafter, the publishers abandoned the agency practices and prices fell significantly. That's proof of the pudding that this is an antitrust violation.
But Apple is still holding out. What is at stake here for Apple?
Well, there's a lot at stake, and this may be a really misbegotten strategy because the Justice Department is going to, because they chose to fight this out, the Justice Department and the court is going to impose the strictest relief, not only to stop these practices, but to stop Apple from engaging in anything even marginally anti-competitive in the future. There's a lot at stake here.
Well, all the publishers in the case have settled with the Department of Justice, Apple refusing to settle the claims. In fact, CEO Tim Cook says, quote, "We're not going to sign something that says we did something that we didn't do, so we're going to fight it." Why is he coming with that strong position?
I don't know, maybe in some, tremendously intellectual, esoteric antitrust discussion, they may have a point. But before a court, they don't seem to have many cards to play here. And again, the evidence here is compelling. And the danger of this sort of tough litigation tactics is that the court is going to say, Apple doesn't seem to know right from wrong. I've got to make sure that this order really ties their hands so that they can't engage in any more wrongdoing in the future.
Well, many analysts say that actually the most substantial issue at play here is something called most favored nation status. Can you explain what that is to us?
Well, most favored nation status basically means that you require somebody to give the best price that they give anybody else. Now, when you're a small firm or just entering into the market, that can be pro-competitive. But when you're a dominant firm, that can really force all prices up because sometimes firms will want to give the new entrant a better price, and this prevents them from doing that.
Other than the charges by the Department of Justice, is Apple likely to face class action lawsuits by consumers if it's then found guilty?
Well, there's already lawsuits by state attorneys general, and they can secure monetary damages, and then there will also be class action lawsuits. But again, what's really at stake here beyond the money is a court sort of seeing a major firm that doesn't know right from wrong and having to impose an order that prevents it from any kind of wrongdoing in the future. And the court's going to be really tough with Apple if they decide they violated the law.
Well, why would Apple then fight this? A lot of the other publishers have settled because they don't really have the money to go to trial. But Apple has really suffered a lot with its reputations in terms of the situation with its tax policies and some controversy over its manufacturing process. So why go head-to-head with the Justice Department?
Well, I can't explain Apple's rationale, but Michelle, you bring up a good point. There can be reputational damage from being in a trial like this. Think about how Microsoft's reputation was damaged because of the facts revealed in the trial of its anti-competitive practices 15 years ago. You couldn't look at Bill Gates the same way after you heard his testimony at trial about wanting to cut off the air and squelch Netscape. you knew he was the type of person who wouldn't compete fair. That's the type of exposure that could really hurt Apple long term.
Type of person that couldn't compete fair. We're going to leave it on that big statement. Thank you so much, David Balto, antitrust attorney. Thank you so much for joining us.
Thank you.